This case is extremely straightforward, so I'll jump right into it. The defendant was convicted of first-degree murder, tampering with evidence, and convicted felon in possession of a handgun. One of the first major issues that I'd like to raise to this court's attention is the issue that involves the photographs in this case. Specifically, the defense in this matter tried to introduce photographs at trial, and they were not allowed to do so. I think that's a concern, and this court should also have a concern with that because...
Let's start with, are the photographs in the record?
Yes, so the photographs I believe they wanted were the ones not included in the record. They're, as far as a trial, these are photographs that the defendant wanted to introduce through a witness, Ms. Dinkins.
Right. Are those photographs in the record before us?
Yes, I believe so. I believe the record was
supplemented. The state says they're not.
Okay. Well, then I'll defer to the record.
I guess the question is, if they're not in the record, how are we supposed to evaluate the question?
I think the analysis from the transcripts gets us there. We can supplement the record. I believe that the record was supplemented on this case. Maybe it was not, and I can request a supplement. But for the purposes of the argument, even if the record was not supplemented, which again I'll request, I'll confirm to make sure, the analysis was laid out in the transcript as far as what was trying to be introduced. And I think the issue as it relates to those pictures is more so not the pictures as much as it was the analysis of the trial court. Specifically from the transcripts.
I'm not sure what you just said.
Okay, so what I'm saying is, I'll double check to make sure the pictures are in, and if not, I'll file the motion to supplement. But even if the pictures are not in, I think the issue is ascertainable from the analysis between the defense counsel and the trial court on this issue. Specifically, the defense counsel, and there was a bench conference that occurred during trial. The defense counsel was trying to get a picture introduced, and there's a discussion of this picture in the record. Tried to be introduced through a witness, the fiance, Ms. Dinkins. I believe the trial court's issue was the trial court concluded that Ms. Dinkins was not the best witness to introduce this picture, but I believe the trial court concluded that the defense could have introduced this through the medical examiner, Marco Ross. The problem with the court's analysis is that a preference on who the court believes should be the person bringing in this evidence is not the basis.
Is the picture a crime scene picture or an autopsy photo?
So autopsy photo, it has the defendant laying, the victim.
How is a lay witness the right person to discuss an autopsy photo as opposed to the medical examiner who took the autopsy photo?
I don't believe she's required to talk about it in the terms in an autopsy capacity. Specifically, what this lay person was going to do was say, yes, I was on the scene, I saw the victim, and I agree that this photo is an accurate depiction of the individual that I saw that night. Now, the jury instructions as it relates to credibility of witnesses and things of that nature would have allowed the jury to give weight to that. But she was not going to get on the stand and talk about things in the capacity of a medical examiner or what the autopsy photo represents as far as injuries or things of that nature. She was simply going to say, this individual on this photo is the individual that I seen that night. And the jury can obviously
give... What does that go to? How is that relevant?
So it goes to, so there were several issues. One is that I believe the testimony from this fiance was that she heard him referred to as Trigger, or it was spelled on his neck, Trigga, as in, I'm assuming, a trigger of a gun. And on the autopsy photos, you can see that tattooed on his neck. So she not only heard him referred to in this nickname, but the photo would have also shown that, and those were not photos that were introduced by the state before. Now, my belief, I was not the trial attorney, but my belief is that by the time this testimony happened, Marco Ross, I'm assuming, would not have been available. And that's likely why the fiance was called.
That's not in the record.
That's not in the record. I'm telling you from here. That's what I would conclude. But even if he was available, the defense has a right to try their case in a way that is most prudent to the defense. There is no requirement that a defendant use a medical examiner when there was an eyewitness on the scene at that night who can identify the individual. Now, she's not authenticating the photo as being a photo that came from an autopsy or anything else. She would simply be saying that the person on this photo, pictured here, is the person, or at least appears to be the person I seen that night.
Evidentiary, though, how do you get that photo in? She can't testify to the authentic, I can't say the word, but you know what I'm saying.
I understand what you're saying.
Of the photo. So you have to call the medical examiner, get it in through the medical examiner, and then you can ask her about it, maybe that way, but she can't authenticate the photo.
I don't know if she needed to authenticate the photo in order to show it to the juries in this regard. I think once she testifies that this is in fact the person, or appears to be the person who I had this interaction with on this night, and this is what he looks like.
That goes, I think, the rest of what Judge Dyer was saying. She didn't see him on a gurney, on a...
Correct.
I mean, she didn't see him like that, like she was in the photo that night.
Correct.
She saw maybe he looked similar enough after this procedure, but she didn't see him like that in the photo that we don't have.
And that's why it would go towards the weight that the jury would give it, because she would be testifying. I didn't see him laid in this position.
That's
what
right.
I saw.
He was asking, Judge Dyer was asking about the admissibility. So the question is, how do you get the photograph into evidence through a witness who did not see this person in this condition allegedly pictured in this photograph?
And the response would be that they would be able to testify as to how they saw him in relation to that photo, and then that could be published to the jury. Even if our position would be that could at a minimum be published to the jury. I would submit that it can be submitted
Under
to...
your theory,
Yes.
someone who heard a gunshot could be but never saw the gun, could be the one that the state or the defense could introduce the gun with.
No, because in this predicament, or the
No, that's
argument...
exactly what you're arguing.
Well, what I'm arguing is that with Ms. Dinkins, she actually saw the victim, had a face-to-face encounter with him. She would be qualified to say this is what that person looked like. The same way we have exhibits all the time, and the state uses them all the time, where they have a layout or a map of a scene, and they say, isn't this the scene or the way it looked at that night? They're never the ones who took the picture of that layout, and they're always the state's witnesses, to say that's what the scene looked like. It happens all the time. We're saying it should have happened one more time.
Before we
If I
leave,
understand it correctly, the only thing you're really trying to get to is the tattoo.
That was primarily, yes,
Why wasn't the question simply asked of the witness, did this person have a tattoo?
that I'm not sure. But again, that goes to the manner in which the case was tried, which the defendant had a right to try it in a way that made sense to them. And
I agree with that,
Yeah.
except it's pursuant to the rules of evidence.
yes, and I agree with that. And our position is the rules of evidence would have allowed her to say, this individual is in fact, or it does appear to be in fact, the person I saw that night.
But this photograph was never introduced into evidence.
Correct. That is correct.
So consequently, it's just a random photograph of an autopsy that the witness was asked about or attempted to ask about.
Yes, basically.
Thank you.
And which leads me to my next point is the jury instruction. And I would hope opposing counsel and us all can be in agreement with this. The voluntary manslaughter jury instruction was required and should have occurred. For the trial court to reach these conclusions and basically interject itself in this case and says, well, I don't want to charge it because I personally don't believe it should be charged, I think is a problem. It infringes on what we believe to be.
What evidence are you relying upon that's in the record that would entitle you to that jury instruction?
So I think there's multiple things. One is that the issue is, was there an intent, premeditated, to commit this crime? Under the facts of this case, you have an individual, the victim, who was heard with the nickname Trigger. There was references that was heard about whether he had a gun or not, or a strap was the phrase. I think the trial court rationalized this by saying, well, I don't know if the defendant actually heard that, but the person standing next to the defendant heard it, and I don't think it's appropriate for the trial judge to then step in and make those determinations off of
Wasn't there
that.
testimony from I can't remember the lady's name, that said she knew he didn't hear it?
Well, that again would be speculation. She could not know what he knew internally. The fact that it was said out loud is enough to say that there, and again, this is a jury question. The jury can always weigh these things and make their own determinations. There was also a bad neighborhood. It was late at night, and the victim had no basis, from what we could tell, to be there. So he didn't have a hotel room. We didn't understand while he was there. There was some type of physical bumping that he engaged in with the defendant, with this statement made, with this nickname that he has, he was actually called that night, with this tattoo on him, with there being other things that we're not clear about, because there's things that happened that obviously were not on the record, and not everybody heard
So
everything.
even assuming you're correct, Mr. Tootin, that it should have been charged, how do you get around the harmless error argument? Because our Supreme Court's made it very clear that if you charge first and you charge second, and the jury comes back with first, the failure to charge voluntary manslaughter is harmless.
I think the issue here is that once you do an analysis, so if you're the jury and you're trying to make a determination about premeditation or things of that nature, and as your honors, you are all aware, even more so than me, is that what they will do, and they acknowledge this all the time, is they start at the top, which they're instructed to do, and then they go through everything first before they circle back and go again.
Yeah,
And that,
I understand that that's what they're going to tell you, but that's not what the instructions tell them to do. And the law says that they follow the instructions. So I go back to my point. If the jury is told, you review first-degree murder and decide yes or no on first-degree murder. And if you decide no, or not guilty, I should say, then you go to second, and you determine guilt or not guilty on second, and so on and so forth. And the Supreme Court has also said that if they stop at first and never go to second, then the fact that they didn't charge anything else is harmless. How do we get around that?
well, I think the other issue that we have, and is laid out in the brief, is that once you have a constitutional right to a jury instruction that has been asked for, and the evidence supports it, I don't believe we can then jump to the conclusion that it not then necessarily becomes harmless, especially when you look at the totality of the other arguments that's been made about the evidence that has not been allowed in, the different comments in the
I think
impact.
this is a better argument for a different group of people, because our Supreme Court has made it pretty clear that it's harmless.
And I think, and I understand that position, and I just think that, again, when you have a scenario where the jury instruction has been requested and the law allows for it, and when you have, when I would say the judge stepping in, as we've raised in other issues in this brief, I think it comes to the fact of, what are we doing as far as due process, and how fair is this to this defendant and his right to a fair trial? And I don't believe that we would be able to argue or conclude that he had a fair trial if we're saying we're punting on the fact that these things happened and they weren't supposed to, and then in the next breath say, however, that he still had a fair trial. And so I think that those are that's the issue, I think, specifically with the jury instruction. The other issue that was a more novel issue, but I did find it interesting, is the issue about the West Tennessee forensic evaluation. Just to touch on that, what I'll say is I think it was important. This individual did not have an in-person evaluation. It was during the time of COVID. The defendant was a victim of a prior shooting. He did have a necessity to have a more thorough evaluation. And my position would be simple as this. Once the court concluded that evaluation was necessary because it signed the order, and once he didn't get a proper or fully evaluation, it's not then fair to say, well, I did something and that's good enough.
Can you cite another case from the quote COVID time period where this court or our Supreme Court has said that a Zoom evaluation is not sufficient?
No, but again, I will be clear, I don't know of a case with this fact pattern where the Zoom evaluation occurred, and then after it occurred, there was objections and concerns as to it not being enough, and alerting the court that it wasn't enough. I haven't seen that fact pattern. I've seen it
But
where it
I asked that
happened.
question because clearly our Supreme Court felt that during COVID that these were sufficient.
And I believe in some cases they are. I think the exception would be when you have a defendant saying, here's the example where this case, so in other words, I think as a starting point in general, they could be sufficient. I think the only exception that I see is a case like this when they say, look, although that was sufficient for the analysis here, it doesn't take into account these specific issues that require in-person evaluation. Now, had there been some type of analysis where the letter or someone said, no, that would not be required, I think that would be a little different. But that was never said here, and so all we have is the defense representation is, here's why I need additional evaluations, and it's basically unrefuted. No one challenges that. And I think that's the difference. I think it could be sufficient, but for when there's those exceptions. And then lastly, I see I'm running low on time, but I will reference it, the tampering with the evidence charge on the sufficiency of evidence case. I think it's clearly that that's I mean, it's not the most professional, but that's ridiculous. I mean, they could not find a gun, and so the conclusion was he must have tampered with the evidence. There's no way you get to that beyond a reasonable doubt, especially someone in the intoxicated state that even the officers say he was in when they found him. There's absolutely no evidence that he attempted to hide anything, and to just reach the conclusion, because we don't have the gun, that must mean he tampered with the evidence. There's no way that should have been a sufficient basis to find him guilty of that charge. So with those things, unless there's questions, I'd ask that this opinion or this decision be reversed so that he can go back to the trial court and have a fair trial for the first time, since apparently as we sit here today, he still has not had one.
Thank you. General?
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the judgments of the trial court. Unless this court has any specific questions, I'll address the petitioner.
What's in the record?
So my recollection, and I do recall there being some form of supplementation ordered in this case, but I don't believe it was the photographs. I don't think that they were made exhibits for identification purposes. I don't think that they were entered in at trial. So my recollection is the record before this court today still does not have the autopsy photographs that the defendant was specifically seeking to admit into evidence. And so to that point, the trial court properly exercised its discretion when it declined to admit these autopsy photographs when the victim or when the witness could not authenticate them. And that is ultimately what the main question here is that this witness testified that she briefly interacted with the victim, that she at one point said, I think the words, "he drunk," and that she walked by him, and that was it. That she hadn't interacted with him more than that. I believe she did say that she heard someone reference the word trigger, but that's it. And so she simply could not authenticate these autopsy photographs. And I want to be clear, the defendant says, that he was not allowed to admit these photographs. The trial court said you can admit these. You just have to go through the proper witness who can authenticate them. So the medical examiner who took these photographs was able to authenticate them, and the defendant simply did not recall that. Was there
any photograph of the tattoo in the record?
I think nothing directly on point, but during the medical examiner's testimony, when the state admitted several photographs, you can see, I believe, and the state's brief references the specific exhibits, but I believe one of them has the words GGA on a tattoo, and I think you can maybe see a T.
You might have to put two photographs together.
You kind of have to put two photographs together. But again, that sort of, not to skip to a harmless error analysis, but the jury could sort of piece these together, and photographs were admitted.
Was there testimony about the tattoo or about what the tattoo said in the record?
I don't believe there was any specific testimony about what that tattoo said. I believe there was testimony of someone saying that the other individual referenced the victim by the name Trigga. So that was out there, but
so like the medical examiner didn't say he had a tattoo, or is that maybe even the medical examiner's report?
I would, the record would speak more clearly, but I would presume that would probably be in the autopsy report. I can't recall it being explicitly testified to in open court at trial. But again, we're here on this abuse of discretion standard of whether this witness, the fiance of the defendant, could authenticate this autopsy photograph, and the fact is she simply could not. She did not interact with him. She'd never seen the victim before, and there was no proof in that trial that she had seen this victim with the tattoo. Where the defendant was given plenty of other opportunities in a separate vehicle to even recall the medical examiner if necessary to get these photographs in, to the extent that this issue hasn't even been waived for failure to include the photographs for this court to review. State submits that the trial court properly exercised its discretion in declining to admit the photographs with this particular victim, or with this particular witness who could not authenticate those photographs. And then when we get to the harmless error analysis, if this court even wants to get there, it's certainly harmless beyond a reasonable doubt. This, not that's not the standard, but it's certainly harmless. The proof showed this defendant engaging in the provocation, walking up, bumping into this victim, exchanging words, starting to walk away, but then coming back to the lobby and waiting for them, and then repeatedly shooting this victim, I believe 9 times. The fact that this victim had a tattoo would not have changed anything. Unless this court has further questions on the admissibility of the autopsy photographs, I'll move on to the second issue, which is this jury instruction claim. And the defendant submits that voluntary manslaughter as an instruction was required, but the state says otherwise. The state argues otherwise. There was no proof of provocation here. Or on the contrary, there was plenty of proof of provocation. It was all on the part of the defendant. The victim in this case did not engage in any provocation whatsoever. Again, the proof at trial and the video that this court will see when it goes and examines the record shows that the defendant walked up to the victim and bumped into him. I believe it did that. That the defendant exchanged words with the victim. That the defendant even walked away or the victims walked away, and the defendant was going to go. I believe his fiancée testified that she tried to get him to go into her room, and he started to approach that way and came back into the lobby and laid in wait for the victim. And then again, there's no provocation by the victim because his last words were, "Hold on, hold on, hold on," attempting to de-escalate the situation. The trial court properly determined that there was no heat of passion here, and that a voluntary manslaughter instruction was not appropriate. And to your point, Judge Dyer, even if this court were to disagree and think that there's some scintilla of provocation, any error in failing to include this was certainly harmless. Again, as you pointed out, Judge Dyer, the Supreme Court has said when the jury is charged with first degree and second degree, and they come back with first degree, any lesser included that should have been included is simply harmless. And even if this court were to conduct a sort of de novo review, it's clear that there was no provocation and that this was premeditated. If there are no further questions on the jury instruction, I'll briefly move to the third issue, which I want to be clear is a claim that the trial court abused its discretion in denying a motion for continuance. So this is in the realm of a mental health evaluation, but the point here is this was several days before trial, roughly 7 months after the initial mental health evaluation, when the defendant asked for a continuance to have this second evaluation, and the trial court said no. So what we're here reviewing is whether the trial court abused its discretion in denying that motion for continuance, and the state submits it was a proper exercise of discretion. To your point, Judge Dyer, there are no other cases that the state's been able to find that have held that a Zoom mental health evaluation is somehow insufficient. And the state would actually submit that this issue is waived because we don't have the original mental health evaluation. We don't know what that evaluator said, and if they had opined, I could see their entire body, I could see the motions. I have full confidence in this evaluation, or if there were doubts or anything of that nature.
General comment, when you say we don't have, I want to clarify. It's not in the record before us. Was it introduced to the trial court when he made his decision denying the continuance?
I'm sure that the trial court had a copy of the evaluation, because the defendant was found to,
It would have been in the record anyway, yeah.
I don't believe it is in the appellate record.
Okay, I just wanted to make sure, okay.
And so
Well,
it's,
Let
so
me
it's,
follow up on that question. What evidence was submitted to the trial court in regard to the request for continuance?
I don't think there was any evidence submitted. I think it was simply arguments. The defense counsel was asking this judge, hey, this was an evaluation that occurred over Zoom, and we would like it to be in person.
That's the extent of it.
That's my recollection. Again, the record will be more accurate, but I don't think that there was any proof put on at that
No
time.
expert affidavit, nothing like that.
Nothing like that, and that's, again, the state submits that it's waived, but even if it's not, and we're looking at the denial of a continuance, one of the questions is did that denial of the continuance deny the defendant the right to a fair trial? And the defendant would have to put on proof of, hey, if I had this second evaluation, and if I had another expert evaluate me in person, here's what they would have said, and it would have been something different, and we don't have that.
So what's the argument, other than it wasn't in person, what's the argument for the need? What was their, at least counsel's argument at the trial level as to why they needed a second evaluation?
I think that's, my understanding is that the argument was because it needed to be in person, and that their basis was when you're conducting this sort of mental health evaluation, the expert needs to be able to view the defendant in person and see all of their mannerisms and reactions and subtle bodily movements.
So kind of to Judge Stafford's question, he didn't even make the argument that, his school records or his other mental health records would show that there might be an issue that we need to have someone delve into further. It was literally just, you need to see him, and Zoom is not sufficient to see him.
That's my recollection of the record. Again, if the record
Yep.
says otherwise, but here the state would submit that this was an appropriate exercise of discretion, where the defendant had gotten a mental health evaluation and waited roughly 7 months until days before trial. The court was within its discretion to say, no, I'm not going to grant this continuance. And finally, the defendant has brought up a sufficiency challenge today, specifically with regards to the tampering. Unless this court has questions about the first-degree premeditated murder sufficiency challenge, state will rely on its brief for that. But with tampering here, the evidence was sufficient to establish tampering with the evidence that the defendant concealed a gun after committing these crimes. So the proof showed the defendant had a gun on him at this hotel, that he repeatedly shot this victim, and that he immediately fled the scene in a car while carrying the gun with him, and that he drove about 2.5 miles down the road before he had 2 flats. And once police were able to find him less than an hour later, they were unable to find the murder weapon. But there's even more indicia of the intent to conceal than just that. The state would submit that that's enough, that the defendant would be reasonably put on notice that there's going to be an investigation for a murder he just committed, and that the jury could reasonably determine that he hid the weapon simply because he drove away and that the officers were unable to find it. But here, we also have proof that the defendant ejected the magazine from the handgun and kept it in the car. And so that, again, helps the jury determine that the defendant had the presence of mind to eject the magazine and do something with the handgun, that officers were unable to find it, which is, again, meets that threshold of, was the evidence sufficient to establish guilt of tampering with the evidence? If this court doesn't have any further questions, we, again, ask that this court affirm the judgments of the trial court. Thank you.
Thank you. Mr. Tootin, I think you have your rebuttal time.
Yes. Again, I'll just reiterate, to be clear, that we believe the photograph issue, just to narrow it down, and I know that your honors are understanding of the law, but it's our position that the person who can authenticate a photo or take that photograph and place it in the evidence is not required to be the person who took the photo. They are just required to be able to authenticate that the person on the photo is who they believe it to be, or lay a foundation as to why they believe it to be that person, and then the jury decides the rest. That's our position, and we'll obviously accept any ruling your honors make, but we believe that that's the standard.
Was there an offer of proof made regarding that?
I guess it's Not really, in the sense that the questioning started, and then there was a bench hearing, and then at the end of the bench hearing, they were not able to go farther. So it was not really, I wouldn't call that an offer of proof, but it was touched on, but not really fleshed out. I don't recall there being a separate time to just stop and then really dig into it. And again, as it relates to the lesser included issue with a voluntary manslaughter, and Your Honors, I would ask you to consider that not in isolation, even though I understand how the Supreme Court has previously ruled, but in the totality of the circumstances here. It's specifically when you look at the analysis of the trial court during the time the trial judge was saying it would not give this instruction, when you see the transcript, you'll see that the trial court was interjecting himself specifically into this case and not doing so in a way that we would consider neutral and detached. And I think when you take that into account with the totality of the circumstance, it's more than just an isolated issue on jury instruction. It's when you look at the language that the judge is specifically saying, and he's basically changing the standard of what's required. My argument will be transparent in that issue, just when you look at the language on that issue when they're trying to get that in.
Can you give us your strongest argument as to any evidence of provocation by the victim?
Nickname, we know that could be something, but violent neighborhood, late at night, no bases there, bumping the defendant, referencing he has a gun. And again, it's like if I like the color red, but I go to certain parts in this city or California, and then I say the wrong things to somebody with that color on, that's provocation. It's depending on the location and the facts of the situation where you're at. It's a jury question.
How does that have anything to do with provocation on behalf of the victim?
Well, because part of it is we don't have the full story exactly what he said or did. We know that he bumped him. We know that it was a high crime neighborhood. We know it was late at night. We know the victim had no basis being there. We know the victim referencing a strap or some type of weapon. That all has directly to do with the victim, is our position.
Okay,
All right. Thank you.
thank you. As much as we appreciate and have enjoyed Judge Stafford, we're going to take a quick break and let Judge Campbell come back.
All right.